Hello and welcome to the 10-minute Trade Secret Training Series, Avoiding Mistakes when Starting a New Job. My name is Russell Beck. I'm a trade secrets, non-compete, and employee mobility lawyer at the law firm Beck, Riden. What I'm going to explain to you today comes from decades of experience helping companies and employees protect trade secrets, and it's designed to help you start off on the right foot. In today's training, I'll be discussing some common avoidable mistakes that people make when onboarding at a new job. I'll start with a statistic to help explain why companies are legitimately concerned when an employee leaves to join a competitor. The statistic is that over 50% of people admit to taking their company's confidential information when they leave for a new job. That's a big number, and that's just the people who admit it. So that represents a big risk for companies. And just to be clear, it's not necessarily that the employees are intentionally doing something wrong. Oftentimes, they mistakenly think that they're allowed to take the information, and sometimes they don't even realize that they still have it. But whether they took the information intentionally or it was just an innocent mistake, it can be serious consequences. So in today's training, I'll be discussing the steps to take to mitigate those risks, as well as others. But before we get started, please understand, I'm not your lawyer and this is not legal advice. If you feel you need legal advice, or if any of the issues that I discussed today raise any concerns for you, you should speak with a lawyer to evaluate your particular circumstances and obtain proper legal guidance. As we work our way through, remember that the guiding principles are to comply with all lawful obligations and to avoid engaging in conduct that needlessly raises red flags. Maintaining proper business ethics should be your lodestar, or your guide. If you feel that something is wrong, it probably is, and you probably shouldn't do it. So let's get started. You have a new job and I'm sure you want to hit the ground running. But what you do now can mean the difference between having a smooth start and ending up in court. So we're going to talk about 3 common mistakes that people make when starting a new job. First, they retain company information, and worse, they use it at their new job. Second, they try to get confidential information from former colleagues or from a former employer's computer system. And third, they try to solicit former customers or colleagues to come to their new company. Let's turn to the first mistake, retaining or using confidential information of a former employer. As a general matter, once you have left your job, you have no right to retain, use, or disclose your former employer's confidential information. So just like you wouldn't want anyone knowing or disclosing your personal secrets, you shouldn't use, share, or discuss your former employer's confidential information. And your new employer doesn't want you to do that either. They don't want you to bring any information from your former employer. They don't want you to put any of that information on their computer systems. And they don't want you to use or disclose it in the course of performing your job, even if it's just to help one of your new colleagues perform their job. So what does all this mean for you? It means that when it comes to a prior employer's information, retain, use, and disclose nothing. I'm not just talking about those super secret trade secrets like the Coke formula or Google search algorithm. I'm talking about anything that's confidential and gives the company a competitive or economic advantage, no matter how seemingly insignificant. Let me give you some examples from actual cases. Computer code, unpublished scientific research, lab notes, bioassays, formulas and raw materials, manufacturing processes and other processes, plans and specifications for future products and other technical data, customer lists, other customer information like summaries of customer interactions, needs, preferences, and buying patterns, vendor information like where to source specific hard-to-find milled components, financial information to the extent that it's not public or shared with customers, pricing strategies, discounts, and profit margins, marketing strategies, business plans and strategies. Basically, if it has the word strategies in it, it's probably a trade secret and needs to be kept confidential. Even compilations of publicly available information and secret recipes can be protectable confidential information. Think about KFC's secret blend of 11 herbs and spices and Peggy Lawton Kitchen's chocolate chip cookies. You can find all the ingredients online, but you won't find the specific quantities of ingredients, the sequence for mixing them into the recipe, the temperature to cook them at, or how long to cook them for. That's what makes the recipe secret and therefore protectable. It's also important to be aware that even things like PowerPoint presentations and Word and Excel files are typically not yours to keep, even if you just want them as templates. Templates often come with proprietary information or are proprietary in and of themselves. Now, not all confidential business information is protectable, but you should always err on the side of caution and assume that the information is protectable until you're certain that your former employer won't contend otherwise, whether you agree with them or not. A common area of confusion is that people often think that any information that they created, contributed to, or otherwise learned at work and now remember is theirs to keep and use. It's not. Imagine if you worked for the Coca-Cola company, and through your work you learned the secret formula to Coke. You wouldn't be allowed to share that formula with your new employer. You'd need to keep it secret, forever. But because there's nothing that can be done to extract your former employer's confidential information from your head, for current purposes, you just need to remember not to use or disclose that information. And that includes not using the information to avoid a step in the development process or even taking the information and improving on it. That's just as illegal as using the information without altering it. And so is using the information for personal use. Unless your former employer has told you that you can, you can't. Another common area of confusion is that people sometimes think that they can keep information because it's on their personal computer. But where the information is stored rarely matters. If it's the company's information, the fact that you have a copy of it doesn't change that. And while people sometimes think that they can just use information and no one will find out, they're wrong. Employers do find out. Sometimes they find out through computer forensic examinations. Sometimes they find out by reviewing file access logs or print logs. Sometimes they find out by seeing a new product or service on the market. And sometimes they find out from an errant email that reveals the misconduct. And when they do find out, that's when you can expect that what could have otherwise been a relatively smooth start will be just the opposite. The person who took the information may not only have to pay for the harm caused, lose their job, and have their career derailed, but in some instances, they can also be held criminally responsible. And if a former employer's confidential information is incorporated into the new employer's business, the new employer may be precluded from selling the affected product or service, or could lose the entire value of the products or services that benefited from the information. So let's turn to the practical side of how to protect yourself and your new employer. The starting point is to determine if you still have information or other property of your prior employer in your possession, and if so, why? Do you have any hard copy materials? For example, do you have any materials that you printed or that someone else provided to you? Do you have any electronic copies of documents? You might find those on backup drives, thumb drives, or tablets, or maybe in your personal email or online storage accounts. Maybe you took pictures of products in development, or pictures of information on your computer screen, or pictures of a whiteboard you were trying to preserve before it was erased. As you're determining what you have, you need to be careful to avoid reviewing any documents that you locate that are from your prior work. That includes avoiding opening any electronic documents, even if it's just to see what the document is. First, you don't want to learn or be reminded of any information that you don't already know or that you no longer remember. Second, if the timing of your access to information becomes important, just opening an electronic file will typically change its metadata and make it look like you were reviewing it later than you really were. So when you're trying to figure out what you have, don't click on any documents or files or review anything that you don't need to. The point of this exercise is simply to figure out what you may have that belongs to your prior employer. And if it turns out that you have information or materials of your prior employer, you'll need a protocol for returning it, deleting it, or both. If you came into possession of it properly, meaning in the ordinary course of performing your job and not in anticipation of leaving, and you haven't reviewed it since leaving, and you have no indication that a lawsuit may be in the offing, the protocol will likely be relatively simple. But if you took the information in anticipation of leaving, or you have reason to believe that your former employer is likely to sue you, it will be more complicated. The protocol for handling your prior employer's materials will be determined by a highly factual inquiry that's outside the scope of this training, but it will depend on a host of facts and circumstances, including what the information is, what format it exists in, where else it exists, why you have it, when you took it, how you took it, and whether you reviewed it, and if so when, and your relationship with your prior employer, just to name a few. This is typically something that you'll want to discuss with your new employer or with a lawyer. And if you've received notification that litigation is possible, or you otherwise have reason to believe that litigation is likely, all the more reason to promptly obtain advice from a lawyer, and in the meantime, make sure to avoid accidentally destroying or altering any potential evidence. But let me be clear, in no event should you just start deleting anything without first carefully considering all of the circumstances and having a full understanding of the potential implications. Now let's turn to the second mistake, trying to get confidential information from a former colleague or from a former employer's computer systems. Let's start with asking a former colleague to provide you with information. This is a problem on multiple levels, even if you're just asking for information that you used to have access to. For one thing, Your former colleague has obligations to their employer, and if they provide this information to you, they'll likely be violating those obligations. It can easily cost them their job and potentially have even worse consequences for them. And even if you are able to get the information, you've probably also violated multiple laws, potentially exposing yourself and your new employer to significant liability. But what if you can get the information yourself? What if you still have access to your old work email account, or to your former employer's computers or cloud accounts? Accessing those is potentially even worse, and is even more likely to expose you to both civil and criminal liability. There are multiple laws at play, and the consequences of accessing a computer system, including emails and cloud accounts, can be extreme. So don't do it. Now let's turn to the third mistake, trying to solicit customers or colleagues from your former employer. The rules are a bit nuanced, and they vary significantly by state and circumstances. But they're generally governed by contractual obligations contained most typically in 2 or potentially 3 types of agreements. First are non-solicitation agreements, which prohibit certain customer interactions. Second are no-recruit agreements, which prohibit certain interactions with former colleagues. And potentially third are non-disclosure agreements, at least to the extent that you have information that might aid in the solicitation. These contractual obligations can vary wildly, but because the goal of this training is for you to understand how to avoid the common mistakes, we're going to discuss some general obligations and how to think about them. To the extent you think that you don't have any agreements that would restrict you from soliciting your former customers or colleagues, or you think that your agreements aren't enforceable, or for another reason you feel it would be appropriate to veer from the approach that we're discussing, you should probably speak with a lawyer and your new employer to assess both the lawfulness and advisability of a more nuanced approach that's tailored to your particular circumstances, obligations, and goals. So let's turn to the solicitation of customers. When we talk about customers, the rules oftentimes apply equally to referral sources, vendors, and suppliers. The starting point here is that non-solicitation obligations are generally enforceable. That means that you need to understand precisely what's permitted and what's not. Typically, these agreements prohibit you from soliciting customers you worked with or about which you learned confidential information. But sometimes they go further and prohibit you from soliciting any customer of the former employer. And sometimes they even prohibit you from soliciting prospective customers of the former employer. Sometimes the agreements go even further and prohibit you from even accepting business from a former customer. Some states permit every single one of those restrictions, while other states permit only some of them, and other states ban them all. Because of that, you need to comply with whatever the agreement says, at least until you know that you don't need to. And while you may think that you can take your chances, you should know that it's actually quite common for customers to report violations to former employers, or for former employers to find out about violations from an errant email they receive from a customer. In short, until you have clear guidance on what is permitted, you really need to avoid reaching out to customers or trying to bring them to your new employer. The same is true for agreements that prohibit the solicitation of former colleagues. These agreements are sometimes also called non-solicitation agreements, but more properly they're called no-recruit or no-raid agreements. And like customer non-solicitation agreements, no-recruit agreements are generally enforceable in most states and could vary in terms of what they prohibit. Accordingly, you need to understand exactly what's prohibited and what's not. As a general matter, the best way to avoid violating these agreements is to have no involvement whatsoever in the hiring process of former colleagues. Don't encourage them to leave their job. Don't suggest they join you or even tell them how much you like your new job and would like to work with them again. Don't help them to apply for a job or recommend them to your current employer. While in many instances it's actually okay to do some of those things or to provide general career guidance to former colleagues, doing so may in other situations constitute a breach of your no-recruit obligations. And while it may all seem harmless at the time and just a private conversation among friends, employers usually find out, and the liability for a violation can be quite significant. Let's look at some common related questions. What if a customer reaches out to you after you leave? Just speaking with a former customer can be a breach of a non-solicitation agreement, and even if it's not a breach, it can look like one, and it can raise suspicions or even trigger a lawsuit by your former employer. So until you know what restrictions apply, you should avoid those conversations. What if a former colleague reaches out to you and asks if your new employer has a place for them? The answer will depend. Sometimes it's as easy as understanding what your contractual obligations are, but oftentimes there are broader implications. For example, whether you know it or not, your current employer might be trying to hire more people from your former employer, and your involvement could complicate or even derail those efforts. It's therefore always safest to avoid discussion until you've been able to develop a full understanding of all applicable restrictions and any other considerations that may be at issue. Is it okay to communicate with customers or colleagues about these issues through personal email or text? It's only okay if you've already determined that it's lawful and appropriate for you to talk with them in the first place. The medium through which the communication occurs is irrelevant. There's often a belief that personal email or texts are somehow private and therefore it's okay to use them. While they may be private, they're not secret, and they will be discoverable if there's a lawsuit. But more important, even if no one would ever find out, that doesn't make the conduct any more lawful or appropriate. So before engaging in any communication, whatever the method, make sure that it's consistent with the protocols that you and your new employer are comfortable with. Can you help a current colleague solicit one of your former customers or colleagues? Only if you're able to do it yourself. If you're prohibited from doing it yourself, assisting someone else to do it rarely avoids the restriction. To the contrary, it's usually seen as a charade to avoid detection and can be taken as indicating a consciousness of guilt. This is a nuanced area of the law, and you need to fully understand your obligations before you have any communications, direct or indirect, with former customers or colleagues. I'll end with a few takeaways. Everyone wants a smooth transition to a new job, but a smooth transition generally takes planning to avoid even accidentally violating the rights of a former employer. With that in mind, don't use or disclose any information of a former employer, whether you have it physically, electronically, or just in your head. And if you do still have information from your prior employer, make sure you have a plan in place for how to handle it. Don't access or even try to access your old email account or your former employer's information, computer system, or cloud accounts. And don't ask former colleagues for information that you don't have a right to know. Don't solicit your former customers, clients, or colleagues, and have a plan in place for when and how you can talk to them. And don't badmouth your former employer or their products and services. The key is to stop and affirmatively think about the issues in this guidance before you do anything that may create more serious problems. Common sense and integrity go a long way. If something just doesn't feel right, it probably isn't, and you probably shouldn't do it. If you wouldn't want it done to your current employer by a former employee, you shouldn't do it either. And remember, whenever you have a question, ask it. Thank you for your time and attention, and good luck with your new job.